Thank you all for coming today. I'm going to give you a talk today about memory, recollection, and the approach of the courts to eyewitness evidence which is given some time after the events in question. I'm going to start with a question, and I'm going to follow it with an anecdote, and then after that we're going to have a quick look through 2 or 3 cases that I've picked out that I think are interesting or throw up a particularly juicy practice point. Broadly, I'm going to make 3 points. 2 of them are going to be fairly obvious, and the last one is a little bit more subtle. But I said I'd start with a question, so see if we can get this to work. That's quite small, but I'll just read it out. What is the difference between history and the past? And now to seamlessly segue into my anecdote. Before I came to the bar, I was a teacher. I worked in Stockwell in South London. And as part of my training, what I had to do was go and observe some of my colleagues giving lessons. And one lesson I observed was delivered by Helen, who was a history teacher. And it was her first lesson of the year to her brand new, shiny, nervous, sweaty Year 7 class. The students all filed in, and they were handed out a bit of reading to do. It was reading on the Peasants' Revolt, and it was an undergraduate level, or graduate level really, paper. Incredibly technical, very dry, very dense. Easily well beyond the abilities of the students. And after about 5 minutes, Helen's teaching assistant started wandering around the class and talking to individual students, asking them how they were getting on. And predictably, the feedback was they were struggling. So, teaching assistant approaches Helen at the front of the class and says to her, quite quietly, "I think these materials, Helen, are a bit beyond this class." Helen and the teaching assistant continued to discuss this in increasingly loud and intemperate terms until the teaching assistant quite audibly told Helen that her lesson plan was misconceived. Whereupon Helen, in a broad Sheffield accent that I won't even attempt to mimic, bellowed at her assistant that she was undermining her authority, that she wasn't a qualified teacher, and that Helen and Helen alone knew what was best for her class. Cue teaching assistant storming from room, Helen breaking down in tears in front of the class. Well, obviously, having your teacher have a stand-up row with a colleague is about the best thing that could possibly happen in your first history lesson of Year 7. So you could cut the atmosphere with a knife, the nervous energy, the excitement, the discomfort. Gathering herself for a moment, Helen apologised to the students and said, "Look, clearly that was unacceptable. It's your first day. I'm really sorry. There's going to have to be a report to senior management. Sorry to put you in this position, but I need each of you to take a sheet of A4 and write down what you saw. Everyone needs to write down what they saw, who said what, whose fault you think that was, okay? Because the senior management are going to want to read all of it." So these Year 7s diligently spend 5 minutes scribbling out what they've seen, at which point Helen solemnly collected all of the statements. Teaching assistant walks back in, and the conceit is revealed to the class, which I'm sure you've already realised. You're smarter than a Year 7 history class, that it was staged. And what Helen then did was go through these accounts. And obviously, they varied wildly, depending on at what point the students had stopped listening, or stopped reading rather, and started eavesdropping on their teacher. How hard they'd actually found the reading. Did they think the complaint was justified? And again, just the sort of language they used. The accounts were fairly different and fairly wildly so. And again, as you've probably gathered, the whole point of that lesson was about eyewitness testimony. And Helen was exploring with her class that how, as young historians, you should deal with the fallibility of memory, how you should cross-reference, triangulate, look at what different people say to try and reach the truth. And she ended her lesson with the question that I began this talk with, which is, what is the difference between history and the past? And that's something that essentially, although we don't use those words, that comes up in litigation time and time again. And I wonder if anyone in this room is bold enough to volunteer an answer. What is the difference between history and the past? Any takers?
History would be the official version, while the past is perhaps the truth.
Yeah, I think that's broadly spot on. The past is what happened. Now, we may or may not be able to know what that was in any given situation. History is just the stories we tell ourselves about it, okay, which may or may not be accurate. So turning to this talk in earnest, what I want to do is, like Helen with her students, talk about how we as litigators should deal with the fallibility of memory. What is the modern starting point? Well, the starting point in litigation these days is the well-known judgment of Mr. Justice Legard in Jasmine and Credit Suisse. And that's set out, some excerpts of that are set out at paragraph 1 in the handout that I've put in the booklet. If you're sitting there thinking, well, Seth's just said this is a well-known case, but I've never heard of Jasmine, that's because in the Anglophone world, everyone calls it Gestmin, but I'm reliably informed by one of the solicitors who represented the successful party that the correct Portuguese pronunciation is Jasmine. So I'll call it that for fear of being judged by her. I'm not going to run through the facts, again, not least because at least one solicitor in the room knows them far better than I do. But all you really need to know is this was a case in which the claimant was suing the defendant for recommending to them a high-risk, low-liquidity investment. And what the claimant said was, that's the opposite of what our investment objectives were. We wanted low risk, high liquidity. Obviously, they'd lost money on this investment and they were suing. But a substantial difficulty that Jasmine had in advancing that case was when they'd taken out their account with Credit Suisse, a document had been signed saying, we are happy, essentially, with risky investments and we're looking for a long-term return. And the way that the claimants in the case sought to deal with that was to say that was signed as a mistake and we'll deal with it in oral evidence. They sought to challenge it via the oral testimony of their witnesses. So the judge, Mr. Justice Legard as he then was faced with the classical evidential dilemma which plays out in the district registries and county courts up in throughout England and Wales on a very regular basis. Well, the documents say one thing, and the claimant's witness evidence says another. And if any of you practice in mis-selling or misrepresentation, that will be a very familiar fact pattern to you. And in this case, to resolve that dispute, what the judge did is he turned his attention to the nature and fallibility of memory. And I'm told he did that to essentially spare some corporate witnesses who had given evidence that they thought would help their employer, but not necessarily adhered to the truth. He didn't want to have to pot them for that, so he dealt with it in this way. He observed, and the first major quote set out under 1 deals with this, but he observed a few things. One, that the idea of memory as a mental record which subsequently degrades, or a photograph, is just flatly incorrect. Rather, what we know about memory is that it's malleable. It's constantly being rewritten, and in particular, whenever you recall a memory, when you retrieve something from your memory banks, you actively rewrite that memory in doing so. External information can affect your memory, and it may be that you end up remembering something that never happened to you or actually happened to somebody else. All of these things are known, observed phenomena. So that's the theoretical side of things. What were the practical takeaways from this case? Well, I summarise them as follows. The fact that a witness is confident in their memory or has a vivid recollection of something does not mean that that recollection is accurate. Memory is fluid and malleable. It is not like a camera. And the best approach for a judge to take in a case where there has been a significant passage of time between the events that are being discussed and the witnesses getting into the witness box is to base their factual findings on inferences drawn from materials and known facts or probable facts. What that means is the real value of the oral evidence is subjecting that documentary trail to critical scrutiny, because by doing that, you can look at the witnesses and you can work out their personality, their motivations, and their working practices. Turning very, very briefly to the academic background the judge was drawing on, essentially the dominant thinking in terms of memory is that what we remember at any given moment is determined not only by what we see or hear or smell, the input, but also the memories that we already have stored, our expectations, our needs, and our emotional state. So your memory of this talk will potentially be altered by how much you had for lunch or had to drink, your expectations. Have you heard me talk before? Did you enjoy it? Did you not enjoy it? Maybe you need to go to the loo. You wish I'd stopped talking. Maybe you're settling a witness statement next week that will deal with these exact issues and you're hanging on my every word. All of those things will shape the way in which you remember this talk. But that's not the end of it, because equally, when you come to recall, if you ever do, this talk, what you're doing at that time will also shape your memory. Who you're talking to, what you're thinking about. And in the same way that the variables affect the writing, when it is recalled, the memory is also reshaped. Well, Jasmine then gives you a fairly clear answer as to what to do or how the court's going to approach a case where there's documents that can be contrasted with the witness evidence. What about when there are no documents, or when all the witnesses you have were blind drunk at the time of the events? And the Court of Appeals fairly recently dealt with this topic in the case of NatWest Markets and Bilta. It's a 2021 case. And in that case, the Court of Appeal noted, fairly obviously, that there are inevitably going to be cases that don't fit within the Gestmin model. There may be no relevant documents. It might be a case that just turns on a single oral promise made by one person to another with no other witnesses. And what the Court of Appeal says, or invites judges to do in those kinds of cases, is largely as you'd expect. All a judge can do is fall back on the traditional considerations: plausibility, consistency, and the performance of the witnesses. So that is the second obvious point, if you will. Mr. Justice Legat, as he then was, returned to the topic of memory in his final case as a first instance judge. And that's the case of Blue and Mike Ashley. And that is the Mike Ashley of local infamy. And this is a case which answers the age-old question: how should a judge approach the evidence when there are no contemporaneous documents and all of the relevant witnesses were drunk and busy throwing up in fireplaces when the relevant events took place? It was a case that concerned a purported £15 million deal, which had allegedly been agreed in a pub under the influence of between 8 to 10 pints, depending on the witness. And unsurprisingly, there were no contemporaneous documents that could assist the court. There are set out, if you turn to paragraph 5, some of the kind of choice quotes, paragraph 6 rather, some of the choice quotes from this case are set out. I'm not going to read them out in full. And in this case, building on what he'd done in Jasmine, Mr. Justice Legat made two additional observations about how memory works in litigation, drawn from the scientific literature. And the first one of these is phrased in very academic language, but I'm going to unpack it. The first is that when new information is encoded, which is related to the self, subsequent memory for that information tends to be more reliable. I will unpack what that means because that's clearly nonsense. The second is that there's a very powerful tendency for people to remember past events which show them in a good light and to suppress the memory of things that don't show them in a good light or conflict with the way in which they want to see themselves or project themselves. So, unpacking that first proposition, what that really means is that when as an individual you encounter something you see or hear, feel, if it relates in any way to your own sense of self, your own vision of who you are and the persona you want to project into the world, you are far more likely to remember it. So, to use an entirely hypothetical example, Jonathan is fanatical about Mercedes cars. Okay? He is an enthusiast to the extent that it may form a key part of his identity or sense of self. And accordingly, if he's walking down the street and various cars drive past him, what the ratio in blue says is he's far more likely to accurately remember seeing a Mercedes than any other brand of car. Practically speaking, then, if a witness can explain why they remember a key fact with reference to themselves, their identity, and I'll give some examples of how they might do that, a judge following the case of blue ought to be more likely to accept that memory as accurate. And that is a question which is sometimes asked at trials, but not asked actually nearly enough in civil litigation, which is, you say you remember this. All these years later, why do you remember it? What is it about that event which caused you to remember it? The second observation that he made, a little more straightforward, we tend to remember flattering details about ourselves, and as an example that he cites, there was a study of US university students who were asked to remember, what grades did you get in your GCSE equivalents? And when they checked for accuracy these recollections, memories of A grades were largely accurate, about 89% accurate. Memories of D grades were about 29% accurate. So again, we are likely to suppress memories which don't sit with our vision of ourselves and how we want to project ourselves. So pulling all of this together, when we're preparing witness evidence or thinking about a trial, what are some practical takeaways? Well, Jasmine is still running strong, and a starting point is always going to be that memory is fundamentally malleable. And this is, in fact, encoded now into the practice direction, the business and property witness statements, practice direction, best practice schedule at the end. So at an early stage in litigation, be sure to subject your client's memory or account to a cross-examination by way of the documents. Where the documents are sparse, the court is going to revert to the traditional tools I mentioned: consistency, plausibility, and performance. Where your case must depend on eyewitnesses, it will assist, arguably, the credibility of their recollection if they can explain their memory via their sense of self. For example, I remember seeing the defendant say no to that agreement. And I remember that because I was impressed by his bravery. That's something I consider myself to be a brave person, and it really struck me, the bravery of what he was doing in that situation. A slightly kind of conceited example, but you know what I mean. Finally, unsurprisingly, we are less likely to have an accurate memory of things which paint us in a bad light, which is inevitably why barristers' profiles feature lots of stories of their success, but a scant memory of all the times that we've crashed and burned. That is all I have to say. Thank you very much for listening.